Ladies and gentlemen, I am SidAlpha. As the title of the video suggests, Cloud Imperium Games and Roberts Space Industries are being sued by Crytek along with a demand for a jury trial, which was filed in California District Court yesterday, the 12th of December. This lawsuit includes two key components, and as the initial filing is 14 pages long, we'll be summarizing the vast majority of the document, although there are some specifics that I will want to go over. Now first, we should go through the particulars of each of the two allegations, one being breach of contract and the other being copyright infringement. Now, bear in mind that Crytek are claiming that they had a written GLA, or Game License Agreement, that specified a lot of particulars in exchange for the Crytek license at a below-market rate. Those particulars are as follows. First, the GLA stipulated that the license was for Star Citizen itself and not for Squadron 42, which is now classified as a separate game than Star Citizen. Originally, the two were considered merely separate modules of the same game. However, as funding has increased to near ludicrously large amounts, the games have been separated from each other, and then Squadron 42 further separated into an episodic game. The second is the requirement for Crytek trademarks and copyright notices to be prominently displayed within the game, which was originally done via the splash page when one would initially load the game. This was considered to be a critical component of the GLA, and the splash page was removed when Cloud Imperium transitioned the game to Amazon's Lumberyard. This actually ties into the third point of the GLA, in which that Crytek alleged that Cloud Imperium promised engine exclusivity to Crytek for Star Citizen, which means that they would be under a contractual obligation to make use of Crytek solely within their game. These clauses for the trademarks and copyright notices, as well as platform exclusivity, were a design to provide visibility to Crytek, with the trade-away being a below-market price for the license to make use of the Crytek engine. It was also stated in the lawsuit that within the GLA, Cloud Imperium promised to collaborate on CryEngine development. This stipulated that during the game's development period, and again on the final publication of the game, Cloud Imperium would provide Crytek with any bug fixes and optimizations made to the CryEngine source code files, including CryEngine tools provided by Crytek as a complete compilable version. In November 2015, Crytek reminded Cloud Imperium that they had yet to do this, even though development had been underway since 2012. A full year later, in November of 2016, Crytek informed CIG that they were in breach of the GLA. CIG claimed that they were ready and willing to comply with their obligations to provide the bug fixes and optimizations as stipulated in the GLA, but that apparently never happened. In June of this year, Crytek sent another request for the bug fixes and optimizations made, but to date, Cloud Imperium have not held up their end of the bargain in that regard. The fourth point of the GLA covers disclosure of CryEngine technology to third parties without permission via prior written approval from Crytek, and under the direct stipulation that the third party enters into a non-disclosure and non-compete agreement with Crytek. In that area, Crytek alleges that Cloud Imperium has broken their agreement yet again in two different avenues. One being the YouTube video series Bug Smashers that apparently contains within them confidential CryEngine information that was deemed to be confidential in nature. The other was the partnership between Cloud Imperium and Faceware Technologies. In this regard, it's alleged that Cloud Imperium provided access to CryEngine source code without disclosing Faceware's involvement to Crytek, and also without obtaining their written approval, to say nothing of Faceware's failure to sign a non-disclosure and non-compete agreement. And after all of that, the document provides the two counts that are filed for the lawsuit. The first is breach of contract that reads, "The GLA constitutes a writing to which defendant was a party and through which Crytek provided defendants with a limited license to use the CryEngine computer program. The GLA limits the use of the CryEngine computer program to a single video game called Star Citizen. Defendants breached the GLA by using CryEngine to market, develop, and incentivize funding for more than one game, thereby enriching itself of millions of dollars without payment for such use. Defendants further breached the GLA by refusing to provide agreed-upon annual bug fixes and optimizations to CryEngine. Defendants further breached the GLA by, among other things, removing Crytek's trademarks and copyright notices from the Star Citizen video game and related marketing materials. Defendants further breached the GLA by breaking its promise to exclusively use CryEngine in the Star Citizen video game. Crytek has suffered and will continue to suffer harm by defendants' past and ongoing breaches of the GLA and is entitled to monetary damages in an amount to be determined at trial. This is followed by Count 2, copyright infringement, that states as follows. Crytek is the copyright holder of the copyrighted CryEngine computer program. The CryEngine computer program constitutes copyright expression protected by 17 U.S.C. subsection 101. A true and correct copy of Crytek's application for copyright registration is attached as Exhibit 1. Defendants have reproduced, displayed, and distributed unauthorized copies of the CryEngine computer program to which they had access. Such unauthorized copies exceed the permissible license terms and therefore constitute unlawful reproduction, display, and distribution of the CryEngine computer program. Defendants' acts violate the exclusive rights of Crytek as the copyright holder to reproduce, display, and distribute the CryEngine computer program and to create derivative works from it as set forth in 17 U.S.C. subsection 106. Crytek is informed and believes and thereon alleges that the infringement of Crytek's copyright was willful, reckless, and/or in blatant disregard for Crytek's rights as a copyright holder, and as such, claims willful, exemplary, and enhanced statutory damages and/or a preclusion from claiming certain deductions or other benefits during the calculation of damages. Defendants' infringements of Crytek's copyrights are the direct and proximate cause of damages to Crytek, and Crytek is entitled to compensatory damages in an amount to be determined at trial. Crytek is further entitled to recover from defendants all of the gains, profits, and advantages they have obtained as a result of the infringement and for disgorgement of any potential gains, profits, and advantages defendants obtained that are attributed to their infringement of the CryEngine computer program in an amount to be proven at trial, together with attorneys' fees and costs pursuant to 17 U.S.C. subsections 504 and 505. And then, of course, we have the prayer for relief, which includes monetary compensation that reads, Plaintiff respectfully requests that this court enters the following legal and equitable relief in favor of plaintiff and against defendant as a result of its infringing conduct and other inequitable practices. Part A, awarding plaintiff all direct damages, estimated to be in excess of $75,000, indirect damages, consequential damages, including lost profits, special damages, costs, fees, and expenses incurred by reason of defendant's breach of contract and copyright infringement. Part B, entering a permanent injunction enjoining and restraining defendants from continuing to possess or use the copyrighted work, and a preliminary and permanent injunction requiring defendants and all those acting in concert or participation with defendants from infringing or encouraging, aiding, or abetting others to infringe the copyrighted work. Part C, awarding actual damages and disgorgement of defendants' profits in an amount to be determined at trial, together with interest, attorneys' fees, and costs of suit as provided by law and as set forth in the contracts at issue. Part D, awarding punitive damages in an amount to be determined at trial. Part E, awarding all remedies provided for under 17 U.S.C. subsection 504. And Part F, granting such other and further relief as the equities of the case may require and as this court may deem just and proper under the circumstances. And this seems to be a fairly straightforward matter. If we assume that a game license agreement was signed that did clearly stipulate all of what was previously listed, then it would seem to be fairly damning against Chris Roberts and Cloud Imperium. And if so, this could cause further significant delays and expenditures for Cloud Imperium in a game that has already missed every single deadline and milestone goal put forth by the developers over the course of the past 5 years. Despite the fanatical following Star Citizen has generated, as well as its fanatical detractors, there have been any number of odd behaviors exhibited by Cloud Imperium over the past several years that have only been exacerbated in recent months. With accusations of monetary mismanagement, shell companies, professional misconduct, and a host of others, Cloud Imperium has fought an uphill battle that will become that much harder if this lawsuit were to favor Crytek. While they may have transitioned to Lumberyard, we won't know fully what sort of damage any form of lawsuit or injunction will have on the game's development. Although, if you'll permit me a moment of purely subjective snark, it's doubtful anyone would even notice if this caused significant delays given how much both games have been delayed already. And in response to this, Cloud Imperium has released the same statement to multiple outlets regarding the lawsuit in question, where they state, "We are aware of the Crytek complaint having been filed in the U.S. District Court. CIG hasn't used the CryEngine for quite some time since we switched to Amazon's Lumberyard. This is a meritless lawsuit that we will defend vigorously against, including recovering from Crytek any costs incurred in this matter. which is pretty much the statement that we would expect from any company when presented with a lawsuit such as this. However, I'm sure a great many eyes will be on this lawsuit as it moves forward, as Star Citizen is the largest crowd-funded video game to date, and it will retain a large amount of attention no matter what. But as always, please do let me know what you think about all of this down in the comments below. Special thanks to the 20 and Up Club for their continued support. Their names are in the description of this video. Once again, ladies and gentlemen, I am SidAlpha, and I'll see you next time.